All right. We'll have some late joiners, but we can't wait. We can't wait for everyone. So, welcome everyone. Thank you for joining us. Today we have the privilege of hosting Dr. Rosenzweig. But before we'll delve into his, we'll both delve into the international law. I want to tell you a little bit about our organization. So, we're the International Diplomacy Initiative. Sorry, hold on. I made a bit of a mistake with the started with the last slide instead of the first one. My apologies. All right. So, we're an NGO. We aim to educate and empower the next generation of diplomats, international relations professionals. We're committed to providing immersive and practical learning experience that extends beyond the traditional boundaries of academia with things such as this lecture, for example. We're a very new organization. We were founded in 2020, right in time for COVID. We currently have a little more than 400 members, and we're still growing. We have four main objectives. We also have various ones. These are the big four, which is first of all global networking. We want people to get to know each other. Cultural understanding as to helping people from different places around the world to get to know, not just get to know the person, but also more about where they're from, a little more about the background. And practical exposure, again, such as this lecture, to understand about specific, more knowledgeable and specifics, be that international law or theories in international relations and practical events currently happening. I'm trying to encourage innovations and working in diplomacy, encouraging different practices and other things that are not just the official diplomacy between diplomats, but also between just ordinary people, like us, everyone here. I'm from the outreach team, as you can see here. We have a president of our organization, Tal, is also here with us. We have Lydia, who also just joined. I can see who just joined in with the camera, and Camille, who couldn't join us today, unfortunately. I'm the third one, and Paula, who also helped and did incredible work. So we are building different chapters. We originally started in Israel, in Weizmann University, and we're working on growing in other countries as well. Our goal is to make an international organization. We want to make an international community. So while our origins are currently from Israel, we're always working to expand and trying to be more actually with more and just more and more. Currently, we established a chapter in Germany. We also have a chapter in Italy, and we're working on both Ireland and a few other countries, which we won't delve into too many details. And as for today, and this is part of a series of speaker series where we have different lectures. So this is actually the second event. Some of you might have been already in the first one as well. Which are the goals of this series is to just share knowledge, right? We want to educate both students and anyone who is interested. Well, allegedly our target audience is students. It's not limited to students where those are open events that we're trying to reach everyone. And our goal is to create a dialogue and share information and knowledge to help people learn more. And we think this is very important, as I said in the very beginning. Our main objectives is mostly educational and creating networks. We want to get people to know each other and also want to share information and knowledge. So as I said, this is the second event. We have more events coming. We have on January 9, sorry, I can't pronounce the name, who will talk about how to bridge divides, how to work towards peace in conflicts. On January 22, we'll have Gregory talk about Biden's policy regarding the Israel-Hamas war. On January 5, we'll have Professor Eli Alon about understanding policy through culture. In February 19, we'll have Yasmin Sayed, sorry if I mispronounced it, about global shifts in anti-Semitism. Now, these events are also about trying to be related to current events. This is currently what we have planned, and it might change depending on what will happen. We'll try to keep these events to be as current as possible, which is why a lot of these are right now focused on Israel-Hamas war. So again, thank you for joining us. You can connect us if you to follow us on social media. You can also reach us in mail. We have a QR code here to see us on Instagram. And we also have a website. So if you also, I'll go back to this slide later if anyone is interested. And blissful holidays. Happy New Year from us in the International Diplomacy Initiative. All right, so let's delve into the more interesting part. Dr. Rosenzweig, thank you very much for coming. The stage is yours.
Thank you. Let's take down the PowerPoint and I'll be able to start. Okay. Thank you very much. Thank you for the invitation. Thank you for organizing this kind of events. I'm Dr. Ido Rosenzweig. I'm Director of Research of Terrorism, Belligerency, and Cyber at the Minerva Center for the Rule of Law Under Extreme Conditions at the University of Haifa. I'm also the chairperson of ALMA, Association for the Promotion of International Humanitarian Law, an Israeli-based non-political, non-profit organization which aims to promote the knowledge, understanding, and discussion of international humanitarian law. International humanitarian law is also known as the laws of armed conflict. I want to be clear about what I'm going to talk about today and what I'm not going to talk about today. So I'm going to talk about international law aspects that are relevant to the current conflict between Israel and Hamas, also known as the Iron Swords conflict, from everything that began on October 7th. I'm not going to go too much into the complete history of the region, and I'm not going to give you any Israel government position. I'm going to give you my professional perspective on things, which sometimes going to be criticizing Israeli government, sometimes going to be criticizing the UN, and sometimes it's going to be just presenting what the law says about different aspects of the situation. So I am going to talk about several international humanitarian law aspects related to the conflict, like the siege and collateral damage caused to the civilian population. And since this is under the auspices of the International Diplomacy Initiative, I thought that it would be relevant to address several diplomatic aspects like statements given by UN organs and UN officials like the Secretary General or the Special Rapporteurs, some of the resolutions that have been either vetoed or adopted by the Security Council and the General Assembly, and the relevant calls for ceasefire that we've been hearing from time to time. So if time allows us, I'm going to talk about other things as well. But generally, we have saved enough time for Q&A at the end. So if you do have questions, either write them in the chat or wait for them towards the end of the presentation, which should take about 30 minutes, give or take. So I know that generally speaking, people know the background of the situation, but I think I'm going to go through it quickly in order to make sure that we are at least on the same page of what I'm going to want to present here. So on October 7th, which has been marked down as a very horrific day in the history of Israel, ever since one of the worst days ever since the establishment of the State of Israel, Hamas and other Palestinian armed groups and individuals entered Israel, and started the attack. Thousands of rockets were launched towards Israel, more than 1,200 casualties, soldiers, but mainly civilians. Over 240 hostages were taken from Israel to the Gaza Strip, and basically the most blatant violations of international law, including intentionally targeting civilians, uh, indiscriminate rocket fires, sexual violence, including multiple instances of rape. We've seen cruel and inhumane treatment, such as burning families alive and killing them together, either shooting them, etc. And all of these actions, all of those attacks were basically violations of international humanitarian law, and then they were probably almost each and every one of them constitute either war crimes, crimes against humanity, and maybe even crime that meet the definition of the crime of genocide under international criminal law. As a response for that, Israel has launched a three-layered operation, which is under the name of Iron Swords. The first phase was basically managing the attack within Israel. So getting control and targeting all the Hamas fighters that entered Israel and basically occupied some of the Israeli towns and kibbutzim in the south of Israel. And that was quite intense part of the fighting. It took a couple of days for Israel, even more than a couple of days, for Israel and the IDF to gain control back over that region and push back Hamas and other organizations into the Gaza Strip and basically either killing the fighters or detaining the ones who were captured. The second phase was an airstrike campaign, which started maybe on October 7th, but mainly on October 8th, and started and is still ongoing today. Most of the airstrikes took place in the northern part of the Gaza Strip, and during that phase, Israel also issued warnings to the civilian population in the north of the Gaza Strip that urging them to temporarily move to the south of the Gaza Strip, where it was safer for them and there was more access to food, water, medicine, and general humanitarian aid. On October 26, the third phase began, a ground operation alongside the airstrikes. This part of the operation, this phase, is still an ongoing one. Since the beginning of the third phase, Israel has suffered more than 100 military casualties, soldiers, combatants of the IDF. And according to available reports that we have from the second phase, from the beginning of the airstrike, more than 15,000 people have been killed in the Gaza Strip, among which it is reported that about 2/3 of them are non-fighters, namely uninvolved civilians, including children and older persons, etc. In the middle of the third phase, there was a short humanitarian ceasefire, which allowed for the release, the gradual release of over 100 hostages from Hamas, in an agreement which also required Israel to release prisoners and detainees in return. The release was facilitated by the International Committee of the Red Cross, the ICRC. And as of today, as far as I know, that according to formal publications, there are about almost 130 hostages that are still being held by Hamas. Now, at this point, I want to emphasize that the mere taking of hostages is a war crime, regardless if you're taking soldiers or you're taking civilians. And more than that, the holding of hostages is a continuous war crime, and holding them incommunicado is also a crime against humanity. So that specific part is something I just wanted to emphasize. Now, lastly, within the framework of the background, is relevant to mention that Israel is also facing a threat and attacks from the northern border of Israel, from Hezbollah in Lebanon. And in this conflict, we have discovered a new front, a new enemy, which is the Houthim in Yemen, which that's a new front that Israel has never experienced before. So if we look at that framework, we can see that the entire Israel versus Hamas conflict is what we usually refer to as a classic asymmetrical conflict. On the one hand, we have a quite strong state, which is obliged by international humanitarian law, international law in general, and usually tries to follow the law and operate in accordance to its obligation. On the other hand, there is a non-state armed group, which is not only sees itself as not bound by international law, but also usually its modus operandi is to take advantage of the rules of international humanitarian law and the fact that the state they are facing is obliged by those rules in order to gain some advantage, and you can see that in the way they operate. It comes into play, for example, by violations of the principle of distinctions under international humanitarian law, which require us to differentiate between our combatants and civilians, and also to attack only combatants and military objectives, and not to attack military civilian objects or on civilians, uninvolved civilians who are not taking direct part in the hostilities. The launching of indiscriminate rocket attacks towards Israel, which in this round began on October 7 in a very massive attack, and still today we have suffered such an attack. I entered into the safe room in my house a few hours ago because we had a siren, because there was a massive attack towards the center of Israel where I reside. We also see Hamas using human shields in several different ways. They use perfidious attacks, trying to pretend to be civilians or disguise as people who have surrender in order to attack IDF soldiers within the Gaza Strip. And that way of operating, the perfidious ways, is not only a way to make the fighting more complicated, but it also undermines the mere defense that the uninvolved civilians are entitled to, which at the end of the day leads to more collateral damage and undesired damage to the civilian population in the Gaza Strip. Now, we can have a full talk. I said I'm going to talk about 30, 40 minutes. I can talk twice that long and even more only about international humanitarian law aspects, but I don't want to do it in this framework. If you want to see the presentation that I do only on international humanitarian law, it's on, I've done that, I've recorded that kind of presentation. It's on Alma's YouTube page. Just look for Alma's Alma IHL, or just Google me, and you can find all the relevant links. And you can find a really thorough discussion about international humanitarian law, the laws of war, aspects of the current conflict. In this talk, in the context of IHL, I want to talk about two main aspects, two main focal points that we've heard a lot about. One is the use of the siege and the accusations of starvation of the civilian population in Gaza. That's one. And the second one, within international humanitarian law, is the question about the massive number of civilian casualties from IDF attacks. So with regard to the siege and starvation, there is no doubt the situation of the civilian population in the Gaza Strip is severe, especially in the south of the Gaza Strip. There is a severe shortage of humanitarian supply. including food, water, medicine, etc. The situation is based, at least partially, on the decision of Israel to impose a siege on the Gaza Strip. At the beginning of the conflict, it was a severe siege, and then it got decreased. And the decision of Israel also to encourage the civilian population to move to the south, which caused overpopulation of the south of the Gaza Strip with regard to the area and the ability of that area to host that amount of people, which by its own will cause a severe problem in the south of the Gaza Strip, let alone during the non-conflict, where there is a problem with getting all the supply and all the goods that are needed. Another reason for the shortage is the fact that Hamas has reserved significant amount of fuel, water, and food in Gaza for its own military purposes. So the mere fact that instead of allowing the civilian population to use all the goods, they are actually keeping a significant amount of it to their military needs, and therefore, even though there are claims that there is enough fuel in the Gaza Strip, it is not distributed to the civilian population, and therefore the civilian population has shortage of fuel, which is usually used for hospitals and cleaning of water, etc. Now, during the first days of the conflict, Israel prohibited the entry of humanitarian convoy completely. But after a few days, the convoy was allowed to enter, especially into the south part of the Gaza Strip, and later on, even partially during the ceasefire, the humanitarian ceasefire that took place, Israel also started to allow fuel go into the Gaza Strip. Now, with regard to water, we need to be aware that the dependency on water from Israel was not significant to begin with on October 7th and before that. Approximately only 10% of the water in Gaza come from Israel. With regard to food, etc., other supplies, as fuel as well, UNRWA storage. UNRWA has storages that actually saved significant amount of food and fuel, and at least for the first few days, I'm not sure that the claims for a severe shortage were actually based. Later on, there was a phase of time that there was a shortage and Israel still didn't allow enough to go in. And that was the origin of the actual severe shortage that is right now taking place in the Gaza Strip. Now, a siege on its own is not a prohibited method of warfare. It is very old, very well known, and very common practice during a non-conflict. The main question is how it is being done and who is it being done against. A siege must be conducted against the military, the adversary forces, and only for military purposes. It is not allowed to be conducted directly against the civilian population, and it is strictly prohibited to use starvation of the civilian population as the method of warfare. This is completely prohibited. And you could argue that from that interpretation, there is legitimacy to use starvation of the civilian population against the adversary combatants or the adversary fighters. But this is a question of interpretation. The main thing is how do we treat the civilian population, and how do we avoid disproportionate damage or excessive damage to the civilian population while we are doing that kind of siege. So the obligation of Israel as the force that is conducting the siege is to ensure that the siege is conducted against military targets, namely against Hamas and its fighters, and to allow humanitarian aid, to facilitate humanitarian goods. And specifically, we're talking about food, water, and medicine, which actually appear in the Geneva Conventions. And this is what the besieging side is required to allow into the besieged area. And for that matter, fuel is not mentioned in the Geneva Conventions. And therefore, there is a question, because if a hospital is unable to operate without fuel, what is the purpose of allowing medicine if you can't actually operate the hospital? And this is a question of interpretation, because fuel doesn't appear explicitly in the Geneva Conventions for that matter. And food, water, and medicine actually explicitly appear, and that this is codified and written. Now, another important thing is that Israel is not obliged to provide the humanitarian aid or the humanitarian supply. It is required to allow the entry of such goods. So the practice usually is that the International Committee of the Red Cross and other humanitarian organizations will actually do the transformation, the transfer of the humanitarian goods. And Israel is just not allowed to prohibited that kind of entrance into the Gaza Strip. At the same side, at the same page, the besieged governing body, the Hamas for that matter, also has obligations. Its main obligation is to provide to the civilian population in that area all the necessities to survive, which means to distribute the fuel, food, water, and medicine that goes in. The obligation is that humanitarian supply, Hamas has an obligation to provide it to the civilian population and not to take it for military purposes. Unfortunately, I'm not sure that Hamas is following that obligation. At the same time, we don't see in the international community much discussion about that kind of obligations that Hamas has as the de facto authority in the Gaza Strip. I would put one asterisk in the discussion. There is an important aspect of the discussion, which is what is the status of the Gaza Strip? And that question can be divided to 2, 3, and even more options. One argument is that the area is under the occupation of the Israeli authorities. Another option, another version, is that occupation ended when Israel disengaged from the Gaza Strip in 2005, in September 2005. And the third one, which is not necessarily contradict the other two, is that the Gaza Strip is part of the Palestinian state, which includes the West Bank and the Gaza Strip. And therefore, there is also a question of whether or not Hamas represents the Palestinian people and the Palestinian government or not. Each one of those options will affect the analysis of what Israel is allowed to do and what Israel is obliged to do in the context of the humanitarian crisis that we have in Gaza. Clearly, if Israel is the occupying power and has complete effective control over the region, it has a higher threshold of responsibilities towards the civilian population in the Gaza Strip. However, it is my opinion that Israel is not the occupying power in the Gaza Strip, and once it disengaged from the Gaza Strip in 2005, and there are no longer any boots on the ground, and Israel has no ability to affect the day-to-day lives and actually govern in the Gaza Strip, it has finished its obligation, and the occupation ended once Israel disengaged. Other alternatives, as the international community holds, for example, the International Committee of the Red Cross and the UN. They have developed this kind of functional occupation where Israel is still the occupying force, but it has the obligation only to the extent that it has power. So, and that usually is limited to the borders and the water fuel, water to the level of 10%, fuel to the extent that it comes from Israel, etc. I personally, professionally, I don't subscribe to that option, but I acknowledge that it exists, and I think it's important to present it whenever I present what is the status of the situation. Now, given that situation, we have to acknowledge that Israel, on its side, has by no means been perfect either towards the civilian population. Only recently, Israel has started to allow the entry of humanitarian convoy from Kerem Shalom crossing. Until now, it was only allowed to go through Rafah crossing, which goes from Egypt. And that crossing, Rafah crossing, is not meant for that amount of trucks and general entrance to the extent that Kerem Shalom is available for and is ready for. Kerem Shalom is the crossing from which trucks should cross and not Rafah. And the fact that Israel didn't allow for basically merely internal political reasons mainly to humanitarian convoy come through Israel and through Kerem Shalom crossing significantly limited and didn't allow as much humanitarian aid as Israel should and could have provided, or at least allowed to go into the Gaza Strip. This invited for international pressure over Israel, against Israel, and eventually Israel has allowed humanitarian convoys to go through Kerem Shalom crossing just as well. But there is, at the end of the day, a significant gap or a distance between the allegations that were even recently made by Human Rights Watch, for example, in its recent report, which blames Israel for intentionally and deliberately use starvation against the civilian population as a means of warfare. And I think that the report is giving a significant weight to marginalized politicians who say awful things, for sure, in the context of the conflict, but politicians that have zero impact on the way the government and especially the IDF operate in the field. So there is a big difference between the intentions of Israel to actually provide humanitarian aid, the limitations from political aspects to use it for Rafah and through Egypt and not through Kerem Shalom, and finding and concluding that Israel is actually intentionally starving the civilian population, which it's just a huge leap between one to the other. And I think that report, which suggested that, which was published, I think, 2 days ago or something like that, is not doing good enough of convincing to actually show that this is the situation, that this is what the intention of the Israeli government in the Gaza Strip. Similarly, we've seen claims about indiscriminate and disproportionate attacks by the IDF in the Gaza Strip, which are mainly based on the number of uninvolved civilian casualties. And those claims ought to be examined more thoroughly. Now, I should note that I'm looking at that question of the collateral damage from a legal perspective and not from a moral perspective. Now, one could definitely argue and reach different moral conclusions about the situation and about what is allowed and what is should or should not be allowed. But the legal analysis is supposed to be more accurate, more clean, and definitely clearer. And as an international lawyer, I'm definitely not moral and expert in moral and ethics of warfare. I tend to stick to the law and what the law allows and doesn't allow during an armed conflict. Now, when we look what Israel is targeting and why Israel is targeting that, we need to understand what is the definition of a military objective or what is considered a civilian object. And the test for that appears in the Article 52.2 of the Additional Protocol 1 to the Geneva Conventions. It reflects customary international humanitarian law, and Israel is obliged by that and has said so many, many times, and there is no question about that. That article, that clause, set a two-layer test of what constitutes a military objective. So the first part of the test is that the object provides military advantage by its nature, location, purpose, or use, right? And the second part is that the destruction of that, attacking that object would offer an immediate military advantage. Now, it is clear that all military targets must fit that criteria, must fit that. And then we can go and then go through what is nature, location, purpose, or use, but generally speaking, the idea is that if a civilian object which is generally civilian is being used for military purposes, it becomes a military objective. And that goes for a car, a civilian car that is being used to transfer combatants or fighters from point A to point B, a house which is used as an arsenal, even a hospital which is used for military purposes, such as hiding weapons or explosives, or locations for snipers or headquarters for the adversary. It loses its protection as a civilian and it becomes a military objective. Now, the fact that it becomes a military objective doesn't mean that we are definitely allowed to attack it. It means that we need to consider if we want to attack that and take into account all relevant precautions and other restrictions which are part of international humanitarian law, such as the use of means and methods of warfare, and giving advance warning, and cancel an operation if it might be cause excessive disproportionate damage, etc. So I have to analyze each and every aspect before I decide to attack a legitimate military objective. So if I know that civilians are either located in that facility or might be harmed by that attack, I have to examine the question of proportionality. Now, proportionality means that I'm not allowed to cause by that attack, let me rephrase that the anticipated collateral damage from the attack is not excessive towards the expected military advantage from that attack, which means that if I analyze the expected collateral damage from the attack and I balance that versus the anticipated military advantage from that attack, only if the collateral damage is excessive towards the military advantage, I'm not allowed to conduct the attack. Anything else, any lower level of collateral damage, I am allowed, it won't be considered disproportionate attack. Moreover, what is most important in this aspect is that we want to, and we have to, examine the ex ante information that the attacker had, and not the ex post facto outcome that took place in real life, what happened. So if I'm attacking a building and my information, I've done everything, I've taken all relevant, unfeasible precautions and gather all the information that I've had under the circumstances. And I think that there are 5 civilians in the facility. And I consider 5 civilians not excessive collateral damage, but apparently my information wasn't good enough. And there were 20 civilians in there, and 20 civilians have died. And we agreed that 20 civilians is excessive collateral damage. Then under international humanitarian law, I'm being analyzed according to the 5 and not according to the 20, according to what I knew at the time of the attack and not actually what happened de facto because of the attack. And this is where it becomes very complicated, because anyone who wants to analyze whether or not the attack was proportionate or not, was excessive or not, has to know what I knew at the time and has to analyze it according to that. And no humanitarian actor who would be on the ground, who would look from the media reports of what was the de facto outcome, would know what I expected to be the collateral damage. And even more so, they wouldn't know what was the expected military advantage for me from that attack. And that makes any accusation of disproportionate attack or even attacks against civilian objects problematic because of lack of information. What definitely should happen in this kind of situation, and usually happens, as we've seen in Israel's practice in the past, is that Israel usually publish a report following the conflict, after the conflict, or if the conflict is long enough, even during the conflict, explaining some of the most, let's say, call them famous or more, the ones that appeared most in the news, or accusations of violations that might have taken place during the conflict, and actually explain what was the military target, why it was classified as such, and why the attack was legal, or if it considered to be problematic, what kind of investigation has taken place following that attack. So I have no reason to think that the Israeli government would not publish such a report. And if they won't, I think there would be a very strong outcry from the local humanitarian and academic population just as well. Now, the last thing I want to talk about is the notion of statements. And I'm going to address that a bit shortly, because I do want us to have also a Q&A aspect. And I think in the last couple of months, we've seen a lot of statements made by different officials and experts in the UN and outside of the UN. We've heard the UN Secretary General saying that the attacks by Hamas did not happen in a vacuum. He condemned the attacks by Hamas and then said, well, that we have to acknowledge that the attacks did not happen in a vacuum, which was a very unfortunate statement by the Secretary General, and it was perceived as justifying or giving an excuse for the horrific attacks of October 7th, and it was highly criticized for that statement. But we also saw statements by a lot of the UN special rapporteurs, either jointly in this kind of format, this or other, or separately, saying statements on raising concern on different violations of international humanitarian law in the context of the conflict by Israel and the IDF, from indiscriminate attacks and up to signs of genocide that Israel is conducting in the Gaza Strip. And they also called for the permanent or consistent ceasefire in the region. As I explained before, some of these, or most of them, or even all of those statements are problematic because they are based on a severe lack of information by the special rapporteurs and others who have made those statements. And there is a little bit jumping to conclusion and a bit being too quick to blame in this kind of situation. Now, on December 7th, following a very unique act by the Secretary General, who invoked Article 99 of the UN Charter, which asks the Security Council to hold a session on the situation in the Gaza Strip, the United States vetoed a Security Council resolution which called for a humanitarian ceasefire. On December 12th, the General Assembly adopted a resolution with a majority of 153 states calling for humanitarian ceasefire. Unfortunately, that resolution failed to call for Hamas responsibility and condemn the Hamas for their actions in the October 7th and holding of hostages. We actually seen there were some suggestions made by a few states to actually modify the resolution and positively add a clause or two which directly link the Hamas and call the Hamas and blame the Hamas, condemn the Hamas for their actions. And those statements, those additions were rejected by the General Assembly and actually were even celebrated and applauded, which wasn't a very nice thing to see. There were majority in the General Assembly for those changes, but the majority wasn't enough for the adoption of those addings. Now, I won't go deep into the whole notion of what happens in the UN, but the special rapporteurs, the Secretary General, the General Assembly resolution, and any Security Council resolution that does not take place under Chapter 7 of the UN Charter are basically declarative in nature, and they should be referred as declarative only. Now, we know that the UN is a political body, and we know that political statements should be considered as political statements, much like, as I said, about the Israeli officials and Israeli ministers who said awful things, and those things should not be taken too much into as something that represents Israel either. Now, having said all that, I do want to talk for a few seconds about the notion of humanitarian ceasefire versus a permanent ceasefire. I think the practice shows that humanitarian ceasefire is meant exactly to do that. It's just a short ceasefire to manage the severe humanitarian issues that the conflict has caused. And this is what the call for humanitarian ceasefire is actually looking for. So by having the Secretary General asking for humanitarian ceasefire and having the General Assembly calling for humanitarian ceasefire, we can also see that in the subtext as acknowledging that the fighting might not end at the ceasefire, and this is not necessarily undermining Israel attempts and operation to fight Hamas and to reach its goal in the fighting, which is to restore the security in Israel and mainly in the south of Israel, and to ensure the safe return of all the hostages back home. That was me trying to be brief and cover a lot of issues in a short time. I do hope that it made some sense, and I'm looking forward to hear your questions and your comments if you have any. Thank you.
Thank you very much. I do have questions, but I think we'll see first if there's anyone else can give someone priority if they already have questions. As you can see, you can also either raise your hands, you can also use the Q&A chat option.
Let's start with the first one. Usually helps.
All right. So actually, just earlier this week, I had a class in Jean, and we talked about the factor of statements, like the importance of official statements to indicate the state's policy. I forgot the name for it, and I'm not sure how to translate it to English anyway. About, I mean, I think it was in reference specifically to treaties. Now, you mentioned why we shouldn't address political statements too seriously, but yeah, from what I heard, this is political statements are used for legal considerations when considering what is obligation, what makes a custom into an obligation. So how do we balance when it does have legal value, and when does it not have the legal value?
Yeah, that's a good question. Well, first of all, there is two different types of statement. You have state officials of a state giving statements, like we have ministers giving statements during the armed conflict, and you have statements made or resolutions made in the General Assembly and etc. in the international community. Now, generally speaking, we usually refer to statements made by relevant officials as the Prime Minister and a Minister of Foreign Affairs, which are done in a specific context as something that shows some of the intention of the state and how they see their obligations on international law. At the same time, we also know that politicians are not lawyers, and we need to be very careful on how we read their statements. For example, since September 11 and onwards, we've heard several US presidents saying that the US has operated in self-defense against terror. It's part of its counterterrorism or war against terrorism in Afghanistan, in Iraq, in Yemen, in Pakistan, etc. Now, the way President Bush and President Obama have used, for example, the notion of self-defense didn't make any sense legally. So we could argue that they are trying to reinvent or adjust international law, but they weren't. They were just speaking as politicians to their people, to their voters, etc. And we need to differentiate between statements which are made in the international community. So, for example, when the Prime Minister goes and speak at the UN before the General Assembly, that's a completely different level of statement, which is intended for the international community, rather than a statement made following the October 7 attack, which is mainly aimed towards the internal, for the Israeli population. So we cannot give too much weight to statements that are political in nature, internally political in nature, but we can definitely give more weight to statements that are being made in the international arena and are specifically and clearly aimed for that audience.
All right, thank you. We are about to end time, so I want to show you on the slide with the dates. If any of you do have a question, please, we'll go a little overtime if we need to. We do want to be able to have the chance to ask, but please just raise your hand now or use the Q&A feature.
Yeah, Lydia.
Thank you so much for taking the time. First of all, I have a question regarding all the UN agencies that are active in the area and in the region currently and very much involved in the conflict. And I wanted to ask, because I don't know about the legal aspect of it, if there's any way to hold those very official agencies accountable legally when it comes to misinformation or misreporting what's going on.
So are you referring, for example, to UNRWA and these kind of agencies? Well, it would be very, very complicated to do so. I'm not saying it's impossible to do so, but I'm quite sure that UN has agreement with all states for immunity for its officials and facilities, etc. So the ability to prosecute the UN is, well, theoretically there might be some loopholes in it. Generally, it's not the way to do things. Unfortunately, sometimes it goes quite extreme, but conducting a lawsuit against the UN, I'm quite sure that I know that there is an Israeli law that gives UN agency a certain level of immunity from this kind of prosecution. I'm not sure about the domestic law of each and every other state in the world, but generally speaking, they have a certain level of immunity. And by the way, that immunity is also exists in that sense that you're not allowed to attack UN facilities. And if we go back to 2008-9, the cast-led operation, Israel has caused damage to several UN facilities. And following some process, Israel actually paid more than $10 million compensations to the UN in the process of resolving that problem. I wouldn't put my money on that front either way.
Thank you.
Nicholas?
Yeah, thank you for the insights. Quite interesting how the international law applies in that specific conflict. And I just wanted to ask, when we talked about proportionality or judging proportionality of attacks, how are we to judge this proportionality if we don't have a clear picture about casualties?
Sorry, could you repeat the last part?
Yeah, so how to judge the proportionality if there is no clear casualty count. So, for example, if there are numerous data, maybe less credible from one source and more credible from another, but if there's no clear picture about it, no certain positive knowledge.
So you're saying there is not enough knowledge for the attacker when they attack, or what happened actually on the ground?
No, actually, when there's no knowledge about the actual casualties. So it is right. So we talked about ex ante, ex post analysis, but I see the tendency in international law that it more and more shifts to this ex post judgments. Although it wasn't invented and not intended in this way. But what if we are now in this situation where we have to judge ex post? What would you advise as a specialist in international law?
Okay.
How to touch upon this issue?
Okay, so I would say I disagree with the premise that the legal analysis has changed from ex ante to ex post. The legal analysis is still ex ante, and I think it cross-border, every international humanitarian law expert will tell you you have to analyze ex ante and not ex post. This is, no one would say otherwise. What would be said is that if there is an extreme ex post facto outcome, this actually shifts the burden towards the state to explain why that attack took place, to actually provide more information about the attack and actually explain why the damage was caused, and moreover, why, assumingly, there was such a big difference between the ex ante and the ex post. Was everything feasible being done to gain all the information about what actually happens in that location? And I mean, we can go way back. I mean, to the early 2000s. There is one of the examples that I'm most fond of targeted killing of Saleh Shahade, which was the head of the military wing of Hamas in the early 2000s, and Israel Israel killed him in the targeted killing situation. And Israel, according to the analysis, Israel thought that there would be 3 people other than Shahade, that person at the time. But de facto, about 15 people were killed. Most of them uninvolved civilians. And it was analyzed. And it was determined that the ex post facto outcome was disproportionate. But it was also determined that the intelligence did everything they could at the time, although that was the information presented to the military officials. And because the ex ante information said 3, and the ex post damage was about 15, there was no criminal liability or no misconduct by the military. But it is important to understand that there was an investigation in that process. So the difference between the 3 and 15, for that matter, of that example, was strong enough to initiate investigation, trying to understand, or should be strong enough trigger to initiate investigation to understand why instead of 3, there were 15. Where was the problem? And I think this is what should happen when you have an unexpected large damage to the civilian population. At the same time, a large damage could still be proportionate, even if it wasn't expected. So if the military advantage is strong enough, it can justify even a higher threshold of damage, even if that wasn't the one anticipated originally.
Great.
Do you have any more questions?
Seems there aren't any more questions. If any of you do, again, we're gonna have context.
Well, I think I have a question. Sorry, before we finish, last question. What do you think are the chances of individuals from Hamas, if not being killed in a combat, being persecuted in ICC?
What the chances of them actually being trialed in the ICC?
Yes, it's like a special tribunal for the crimes of Hamas, and it's like actually like
A special tribunal is something else. We're talking about the International Criminal Court in
yes.
The Hague. I think the chance for them to get to the International Criminal Court are somewhere in the area of 0. And for 2 reasons. Well, 3 reasons. One, there's a chance that they never get caught. The second one is that they get killed, as you said. That was also the option. And the third one is that Israel will capture them. And if Israel capture them, Israel is willing and able and has complete jurisdiction over the matter of trying people who harmed Israelis. And therefore, Israel will want to indict them in Israel. I don't see any chance that Israel will extradite them to The Hague for several reasons. One of them is that the maximum punishment in the ICC is much lower than what Israel will probably give them, which will be probably a lifetime in jail for what happened, if not even something else. Any other situation would actually require them to be extradited to The Hague in order for the ICC to actually prosecute them. I do think that there is a very good chance that the prosecutor of the ICC will provide arrest warrants against them. I don't think, other than being caught by Israel, that there is a chance that they will travel into a state that is party to the Rome Statute and therefore is obliged to extradite them to The Hague, to the ICC, to the prosecutor. And therefore, the chances for them to actually be indicted in the ICC are none. They don't exist. It doesn't mean that they won't be trialed if Israel gets get control of them. And there's also the chance that Israel will try to kill them either through conflict or by other means, as we've seen throughout history.
Right, so we really do have to finish. We're already in overtime. So thank you everyone very much for coming. Again, I'll show you the screen with the data so you can follow us online if you want to follow up on future events. And again, happy holidays.
Thank you.